This is Professor Porter. The course is called Trial Techniques. We're in Chapter 2, Trial Advocacy Generally, and the subchapter is the first one, Case Analysis. Case Analysis is kind of an all-encompassing term, a broad term that really means anything that the advocate does or all that the advocate does in the front end of a case to take it from all sorts of, piles of prospective testimony from the many witnesses that you may call and all the information, documents, discovery that could be a trial exhibit. So you have this, universes of prospective trial testimony, prospective exhibits. How do you keep honing it down until what would be your case presentation, or at least the narrow subset that could be the options for your case presentation? So case analysis is where you start to think about you're looking maybe at your closing argument based on the law, based on the jury verdict form, based on the jury instructions that are applicable in the case, particularly the substantive ones, and what do you want to say in closing, where do you want to be at the end, and how do you start selecting the witnesses and the prospective witness testimony that's going to serve that case presentation. And inherent in that case presentation is some of the things that we talk about in the subsequent chapters. You're going to come up with a theory of your case. That's how do you meet, if you're the party with the burden, how do you meet the elements of the claim or the crime? If you're the party without the burden, you might be, how do you disrupt, or which elements are you going to focus on to disrupt the other side's case so they don't meet their burden? But you're making choices about witnesses, about areas of testimony, about exhibits that narrow the case and focus the case down from, sometimes the intimidating and voluminous amounts of information that you have when you kind of get a file or when you've built the case up. You're also thinking about sort of segregating and organizing the facts of the case, whether it comes from a witness's mouth and its prospective testimony, or whether it's an actual document or something that could be in the form of an exhibit at trial. You're narrowing it in your case analysis as to how it serves that theory, how it can be part of the case. Is it a good fact for your side that serves that? Is it a bad fact that you kind of got to pull out and put it on the opponent's side? Is it somewhere in the gray, somewhere in between? When you narrow down the case to, okay, now we have this really subset of a subset that is, the good facts of my case that I'm going to rely on to serve my theory, to center my case presentation around. How do I prioritize those facts? Which ones are the most important facts? Which ones may arise in the testimony of several different witnesses and be corroborated with several different exhibits? So my case analysis is a vicious self-editing process, a team self-editing process. It's a narrowing of your case with a real focus on what do you need to prove or disrupt at trial, depending on your role at trial, and really starting to think of case presentation, case theory. And the last thing that is also a subsequent chapter is the theme. What sort of visceral imagery, what words, what expression do you use to express your case and say something memorable and repeatable throughout your case presentation about your case, so that the other side, it resonates with them. The jury hears these words and they start to understand essentially where you're going and how you think about the case and why that's particularly memorable. The other part is, once you kind of have this narrow subset of the subset, you have this, ambitious case presentation. Here's the stuff I need to put on. Here's the facts that I prioritize. Here's the testimony and exhibits that I know need to be part of my case and are not on the cutting room floor, at least at this stage. Then you have sort of these case presentation options. Does it come through this witness? Is it best through a second witness? Maybe one witness sponsors it and authenticates it and puts in the exhibit and does some background stuff with it, but then you essentially use that now admitted exhibit through a different witness. So you're thinking of the case presentation options and what you might do with this, these prioritized good facts, whether it's through testimony or exhibits. So case analysis is this broad term, this broad description of the process of going from everything involved in the case, just like you have to do in all sorts of aspects of the law, to narrow down and focus. How do I stay on message? What is that message? And how do I keep my presentation really buttoned into what I want to say and how I'm going to prove my case and how I'm ultimately going to be successful at trial.